Good evening and welcome to Transition Talks Tuesdays in partnership with the Columbus School District Transition Program. My name's Tim Markle. I'm director of the Children's Resource Center South. And tonight we are welcoming in George Zaske. And George is going to tell us a little bit more about supported decision making. He brings a very unique background to this topic and a personal background to the topic. And I am very excited that he's with us. George, thank you so much for being here, and we turn it on over to you.
Okay. Thank you, Tim. Um, Tonight I'm going to be talking about supported decision making and guardianship. This is a talk that I've given variations of this quite a few times for a variety of audiences over the years. And I'm making the assumption that I'm talking to parents, but not educators, or is it a mix, or what's kind of my audience here?
That's a great question. I am looking at who is on the here tonight, and we are predominantly family members
Okay.
with a couple of educators thrown
All
in.
right. Okay. Yeah, sometimes I've given this where it's mostly teachers. Sometimes I've had legal professionals, also um, case managers and along those lines as well. So it helps because I have a few, for me, worn out stories. Hopefully they're not worn out in their for you, but it sort of shapes a little bit about which ones I pull down from memory to be able to insert as I go through this. So a little bit about myself. I am a father of an adult son with a cognitive disability. I'm also an attorney. I've done predominantly family law, but I also have a pretty good mix now of estate planning, special needs trusts, and do some guardianship. And I'm a board member for a small agency up here in Western Wisconsin, very close to the Minnesota border. And I'm also on the BPDD board, which is the board for people with developmental disabilities. And so I get to do some advocacy, and I actually was on the working group that worked to draft and get the supported decision-making legislation through. So we have that as an option here in Wisconsin. So that's a little bit about me. And because one of my roles is an attorney, we have two phrases. One is "it depends" when people ask us questions, and the other is a disclaimer so that people aren't thinking they get specific legal advice. I don't know your facts. This is here to educate and provoke hopefully some family discussion around the area of supporting your loved one as they transition out of high school into the adult services world. And it's dramatically different than the IEP teams and things that you have if you're currently in high school or if you're in middle school. It's very different when you hit the adult systems. You don't have the kinds of teams that you have when you're in the education system. I've been my son is 26, so we've been out of the school system for a while, and we'll talk a little bit more as we go. But hopefully, the information you get here, you'll be able to have and talk amongst, with with the other parent, with other family members, and also certainly with the person that you may want to have under guardianship. So, so I already did my audience survey. I'm reaching here, so I have a clock. I want to make sure I'm respectful of time. So that way I've got a clock in front of me. All right. Now I do this every presentation I give, whether it's about supported decision making or guardianship or a number of others that I give. I am very much a proponent of people exploring ABLE accounts for their loved ones. It's another tool that we have. We've been using an ABLE account since 2016. I know there's legislation and you can have one in Wisconsin, and there's legislation now. I believe it's going to go to the governor's desk. I don't know. We're hopeful that he'll sign it, but it's to create an ABLE account infrastructure here in Wisconsin. Previously to this legislation, you were allowed to have an ABLE account, but you had to participate in other states' ABLE accounts. For example, we participate in Minnesota's ABLE account. But it really encouraged people to write down this website and go out there and look if you don't already have an ABLE account, because it gives you more flexibility about how to support your loved one financially if your loved one is going to work, and you want to stay under the $2,000 limit. An ABLE account, it can be a very effective mechanism for helping you do that. So this has been my personal PSA that I've done for a very long time, and I throw it in here in the presentations that I have. So, all right. So wait a minute, do I have? All right, there we go. All right, what is supported decision making? Well, it goes back a number of years. As you can see, it was defined back in 2012, and it's basically supporting a person with a disability. They use family members, friends, professionals that help them understand information and allow them to make the choice. And that is where they retain the rights to make decisions. When you go for a guardianship, and I've done them, I'm not, vehemently opposed to them. I do think they've been overused, but we didn't have very many other options. But there are people who they're appropriate for, and I'm not going to pretend otherwise, but I do have strong feelings about whether or not they should be a full guardianship. There are people I know who lost their right to vote because they're under guardianship, and they're competent enough to vote, for example. But that's the difference between a guardianship and supported decision making. Is the supported decision maker assists the person making a decision, and it can be a medical decision, it could be a financial decision, but that person is the one who retains the right to make the decision. When you get guardianship, then you become a substitute decision maker, and depending on what you've selected in terms of your loved one's rights that they may retain, the right to vote, some others, and we'll talk a little bit more about that as we go through. If you are appointed the guardian after a court proceeding, you are the decision maker. You substitute your decision making for the person who is under a guardianship. What's the current state? I like to point out to folks, even in my time working in this area, there's been significant changes in our world, which makes having more options available to families. Way back in 1999, there was a federal case called the Olmstead decision, and that required that people with disabilities, belong in the community. They don't belong in institutions. So if you're going to be in the community, it helps to be able to have some decision-making authority about, where you live, who you interact with, if you're going to work, how much you're going to work, where you're going to work. And that's different than the historical model, which has been institutions. And so the Olmstead decision was decided so that there was very clear direction that people with disabilities should be integrated into the community and not just segregated into various institutions per se. CMA, which stands for the Center for Medicare and Medicaid Administration, or it should be CMS, not CMA, CMS services, that that also says that long-term care dollars, if you have, some of you may have IRIS, some of you may be under managed care. If your child has turned 18 and you've entered the system, their rule is they want long-term care resources directed towards helping your loved one live in the community. And there are books, there are seminars. If you go out online and search on person-centered planning, that's a mechanism for, in a way, an approach to put your person at the center and do the planning around it. Who's their support network? What are their skills? What skills can be enhanced, etc. Things like circle of support. ABLE accounts, they just came around in 2015, which can provide more flexibility for paying for technology to help the person be more independent, to pay for education. You can also use, representation agreements, things like power of attorney. Some people may use that for their elderly parents. That's an option. Programs like Project Search didn't exist in Wisconsin as it does now back in 2015, where your loved one, after they leave high school or in their last year of transition in the school district, can participate in Project Search to learn job skills. There's an organization called Think College. There are college-based programs for people with cognitive disabilities. There's one in Madison called Edgewater, and there's also one across the river from me in the cities at Bethel College. And you have students there with a cognitive disability. They are supported. They stay in the dorms. They take different kinds of classes. That didn't exist. And that's just another example of how our world is changing. And this is just in the last 10 or 15 years. You look and think, okay, we have some similar amount of change in the future. We could very well have a lot more options for our loved ones, 10 and 15 years from now. Attorneys are being trained. Getting a guardianship was pretty assembly-like, where people would come out of high school. You should get guardianship to help them get their services, to help them with their lives. And so then you go into court and the attorneys would follow their clients' wishes. Now we're hopeful that attorneys have longer, in-depth discussions with their clients about other options. And the other side of this is many people will go without an attorney because they've made it pretty easy to be what we call pro se, which means represent yourself, and do guardianship. And you'll see that a little bit later in my presentation. The ABA came out in support of supported decision-making as an option way back in 2012. And they support that. So, one other thing that, and I should update my slide, but in Minnesota a couple of years ago, I'm licensed in both Minnesota and Wisconsin. They changed their guardianship law so that anyone under the age of 30 can't be put under guardianship for more than 72 months. So it's time limited. I'd love for us to have that, because as this next slide shows, brain development doesn't really finish up until around age 25. That's for any young adult. That has nothing necessarily to do with whether you have a cognitive disability or not. I'm, fond of telling folks there were times in my early 20s where my parents probably thought maybe George could need some support with his decision making because it hasn't been so good. I won't share the details of those because at this age it's embarrassing for me. But I just wanted to let you know that people's brains don't fully develop. And the idea of a time-limited guardianship is to, all right, put somebody under guardianship at 18, 17 and a half. 3-4 years go by, there's some maturation, actual more connectivity in the frontal lobe, their executive functioning is better, their impulse control is better, and they can make better decisions, particularly if they have options to do that. And then if you see that there's been growth and development and better decision making, you got to go back. You had Minnesota and some other states allows for the opportunity to come back and say, you know what, we can dial this back a little bit. So guardianships, when they were put on, years ago, they lasted for 30 or 40 years. And I often will tell parents that it's likely someone else is going to get the guardianship role. Now, that may not necessarily be a family member, like a sibling. You may not have a lot of family members around. And if you say, oh, my sister will do it, well, you're 65 and your sister's 63. How much time does that really, buy you when you move into your 70s and your 80s? So it's very likely somebody else is going to have the role of guardian, and it may not be somebody that you anticipate. It could very well be a corporate guardian. And the challenge with corporate guardians is they have very full caseloads. And here's the areas. I'm familiar, I pay attention to neuroscience and the development of it. My son's underlying disability is epilepsy. So I care about what, brain research and in that area of science when it comes to disability. And these are the ages, or these are the areas that get impacted with the physical brain development. Attention, complex planning, decision-making, impulse control, organized thinking. A big one is risk management. I hear that a lot from parents. I'm worried about my loved one being vulnerable, people taking advantage of them. I get that. But we also have, technology like cell phones, text messaging, alerts on our phones. So there's many things that have changed that can help us support our loved one as we try to get them to have more independence and more autonomy and a sense of self. And this is what promotes healthy brain development: cognitive challenges, education, as I mentioned, Project Search, think college, a rich environmental enrichment, socialization. After high school, are they just going to go into, previously they went into maybe a sheltered workshop or a group home, and that was at a critical time. And research has also shown that at some level, an individual knows they're under guardianship and somebody else will be making their decisions for them. That can undermine their self-confidence. And if you don't, as a parent who oftentimes becomes the guardian, make a concerted effort to really include your child in decision-making, they won't have these opportunities to have healthy brain development. They can kind of, and I've heard it from teachers, is that they run across their student years a couple years down the road and it seems like they've regressed, or they had possibility and potential, but it got stopped. And as parents, we really should be, and I know many of you will be paying attention, but it can be pretty easy that, you're filling out paperwork and you have to make a decision, to just make that decision in the name of efficiencies. Your loved one, they wouldn't mind. And really, you maybe ought to have a conversation with them and say, I'm filling out this form. They're asking what kind of services you need. What do you think? Let's talk about it. Now, guardianship starts out with a petition that starts a court action. And this is the actual guardianship Page 1 of the guardianship petition, it's online. If you go to your county's government website for the courts, you can find this. And as you can see, this form is used for a temporary guardianship and a permanent guardianship. But the key phrase up there is, and that's what the court has to determine, and that can have an impact on your loved one, is everyone, once they turn 18, is presumed competent. That's the standard. That's when you turned 18, you were presumed competent. When I turned 18, I was presumed competent. To lose your rights through a guardianship proceeding, you have to be determined to be incompetent. And if you sit and think with that word for a while, it's a pretty powerful statement. And the challenge or the problem with this is your incompetency. There are varying levels of competency and understanding. I would argue that the understanding and competency that a person needs to vote and participate in our democracy is not as complex as the level of competency you need to make an informed medical decision on a complicated procedure, whether you're going to have brain surgery. I mean, people vote, think about it. They vote whether there's an R or a D. They vote whether they're, Second Amendment, environmental. People make decisions can make decisions, and nobody questions it on very narrow elements when they go into the voting booth. And you are allowed to have help in the voting booth. The only persons who cannot be in a voting booth with a voter is an employer or a union rep. So if your loved one needs help voting, you think, oh, they won't be able to go in the voting booth, they can go in the voting booth with you, and you can help them vote. I've been involved for a number of years in the Disability Vote Coalition, and we want people who have disabilities and they're competent to vote, to make some of those decisions, to be involved, because policymakers are making decisions about what gets funded, what the priorities are, and they're a segment of society that should have a voice. It looks like Ms. Henderson has a hand up.
I do.
Yes.
George, so that was crucial information about having a parent, guardian, or somebody go into the voting booth with you. Is that did you have to show the supported guardianship paperwork in order to do so, or do you just say,
nope?
So anybody can go into the voting booth with anyone?
Now it's going to be interesting in our current political environment with poll watching and all this other stuff that's going on.
Okay.
I would argue that if you do searches for like Wisconsin Disability Vote Coalition, they have a lot of good information about how to go about it. I mean, you don't necessarily want to be, confrontational about it, but poll workers should be trained. I went to our local polling place and I checked with them before on a primary, and I went and I asked them where their disability vote station was, and they had one that you could, for someone who was visually impaired. They had one for someone who was orally impaired, and yeah, it's people. We have sometimes more rights than we recognize and realize, and you might be in a small township and they may not be aware of it or have that training, but you certainly, I would check with your town clerk in your area when you're voting ahead of time, because could be busy on voting day, and just say, this is what we're going to do. Now, personal experience, what we have done in our family is we've signed up for absentee voting. And then we just did it. We've been doing it for years, but we just signed up again online, says, I want to do absentee voting. They will send you the ballots for every election ahead of time. So you don't miss, or it's like, oh, I got to work that day or we're out of town. You get it. And what we do with my son is, if there's a complex referendum or bonding bill, we talk about it. we explain this is what it's about. And then you make your vote, we put it in the envelope and we send it off. So we avoid that aspect of it, but you have to go through the process of requesting to do absentee, sign some paperwork and provide a photo ID. But our photo IDs are on file. So all we ever do is just go in and request absentee ballots, and that's how we vote. But we feel it also gives an opportunity, because I don't know about you, but I've been in a couple of voting booths myself, and I've looked at some referendum, and it's the double, triple negative, and it's like, okay, am I going to vote yes or am I really supporting the yes, no, maybe kind of thing? And so it can help to just, even for a regular voter, to be able to sit with some of those more complex referendums on school funding or some of the other things that may be coming down the line in our political environment.
Yeah, that's helpful because as a teacher of adults with disabilities, I brought 2 students to the polls last year, and I went in and read the ballot to them. And I had to be really clear with parents and, everybody, like I was just going to be reading the ballot. So, it's helpful to know that that's
true. And obviously you can't vote for them. You can't vote for them as a guardian. I mean, there's a box as we go through this petition. I'll go to the next page. And this is how this form's filled out. It's about 7 pages. And I did this one time in a presentation, and I'm experienced, but I essentially gave somebody an actual physical stopwatch in the front row, and I said, time me. And I essentially filled this form out in about under 5 minutes, because I knew the boxes to check. But think about that. I had the ability to create paperwork that would go to a court that would eliminate somebody's so many rights for deciding where to live, medical procedures, right to vote, right to get married. I did that paperwork in under 5 minutes. That's kind of staggering when you think about it. There have been commentators who said that a prisoner who is incarcerated has more rights than somebody who's under guardianship. So it's a powerful thing. And as a parent, I mean, I've been there, wrestled with this. As a parent, you want what's best for your loved one, but can you detach a little bit from being the parent and thinking, are there other ways to providing some safety for my loved one? Can we use text messaging? Can we use cameras on the front door if they're living independently? Financially, can I be on the accounts and they sign a financial power of attorney so I can help them do their bill paying? And that's a very personal individual decision, but it's something that I believe people should go through that thought process, because it's more nuanced. And then so that's page 2. And then you have to identify that what kind of disability. Is it cognitive or developmental? Is it traumatic? It could be other incapacity, and that could be like a TBI, traumatic brain injury. Could be mental illness. And then you go through, and again, you're checking these boxes, and you can check you want to be guardian of the person. And then it says rights to be removed in full. And there's 3 boxes. Remove their right to execute a will, remove their right to serve on a jury, and remove their right to register to vote or vote in an election. Now, you might, if you're thinking about it, maybe they wouldn't be appropriate to sit on a jury. So maybe you check that box. But, the right to vote, maybe you leave that one unchecked, because it's assumed that if it's not checked, they retain the right. So then you go through this, and you can see. Now, the other thing I'd like to highlight is apply for license. This is a big one in Wisconsin. Are they going to be able to get a fishing license? If you check that box, they can apply. And I know that's one where some people, give pause because they're outdoorsers, outdoor families and four-wheelers, and they want to be able to get out and about. So you go through this process. Now, the other thing is you can have within that right, you can check where you can limit the guardian's right because they retain some limited capacity. So there's another thing. I mean, an example I use in terms of financial is, guess what? They can make financial decisions up to, pick a number, $500. They don't need the guardian's permission to do that. That might be something that's appropriate. So now we're done with 4. Here's page 5, the different rights that can be removed, receipt of social services, number E, F, access to release of confidential records. There's ways to get confidential records by having your loved one sign a release. We just went into the clinic a couple of weeks earlier in the fall to get shots. They brought up the records because I transported my son there, and they said, "Oh, your release is expired. Do you want to sign new ones for your mom and dad?" My son said, "Yes." We signed new ones. We've got new ones in the file. And then 5, no, that's 5, 6, and then there's where people sign it, the county, and you've created the petition. So it doesn't take all that long to fill out this paperwork. And there's not a lot of study on this, but when I did some research, most guardianship hearings are done in 15 minutes. Now think about that. All of your rights as a human being in our society can be in the court. I mean, obviously there's paperwork that's filled out, but that can be gone, and you could be declared incompetent, lose your right to vote, lose your choice of where you live, have somebody else make your medical decisions, and all of that is done in 15 minutes. To me, that's pretty profound. Is it the best option? It maybe not. 25 to 50%. Make note, they don't really do much in the way of concrete planning. What does it mean? How are they going to be supported? Who's going to get the guardian? Who's going to be a successor guardian? And another study, and kind of, I think, lulls families, is most individuals with a developmental disability live with their parents well into middle age. And they make the transition in time of crisis, either the death of a parent or a serious medical circumstance. So it basically, I mean, the bottom line, it's court-ordered loss of personal freedoms. And it's very hard to undo or to roll back a guardianship. I helped one family a number of years ago to help their loved one restore their right to vote. And we got it done. It was one of my favorite cases I had. But we had to go through some hoops. We had to, develop evidence. We had to get witnesses. Unfortunately, he had a lot of people who were willing to, I mean, his employer actually got left work to be able to testify and say, he works for me. We have conversations about politics. It seems to me he has well enough understanding about our governmental system. And, he could name who the current president was, who the 2 senators in our state were. And it wasn't just rote. I mean, his teacher said that one of his favorite classes was history. So, and social studies. So that was civics class. So that was his thing. And so we were able to get it. But why I like Minnesota is it's court-ordered loss of personal freedoms for 72 months. Then we come back and revisit it. And that is in place for anyone under the age of 30 who's put under guardianship. If you're over 30, we probably, we should know more about the person. And when you start getting in, and I think this is where the growth industry is going to be in guardianships, is for our frail elders, our parents. They're going to need, it's going to be, maybe you have power of attorney, but it's going to move to guardianship. I mean, I just saw a news article where Jay Leno is applying for guardianship for his wife because she suffers from dementia. We're going to see more of that because our medical science keeps us alive longer when maybe our brains are not the same way our heart health is. This is the Wisconsin guardianship statute that probably has the most significance. And if you look at 3B, even if you're under guardianship, the guardian should make a diligent effort to identify and honor an individual's preferences about where they live, their privacy, sexual I mean, all these things that, some people may not, as a family, want to address. They just want to decide and move on. No, you should be doing that as a proper guardian. One of the ways we've tried to change that or address that is a group of us worked on the guardianship training bill. So now, before you can be a guardian, you have to go through training to be exposed to some of these concepts and understand what your role is as a guardian. It's not the same as a parent. You will always be a parent. I will always be my son's parent, but I'm his supporter when he wants to make decisions. I'm not his guardian. We didn't go down that path. And so far, it's worked out pretty well. Have we had some bumps? Yes, but that's going to happen. And if anybody has the idea that you can have a guardianship order and you can call up the sheriff's department and say, my son Mike is over at his friend Bob's place and Bob's a bad influence. I want you to go pick him up and bring him home. I have guardianship. It's not going to work. That's not how it works. And there are alternatives. You can petition for appointment of conservatorship. If you control the money, can they sign for a lease on an apartment? Can they pay for it? If they don't have the money because you're controlling it, maybe not. So that's something to consider. Yes, Ms. Keys has a hand up.
Hi, if you can hear me, I'm
I can.
Mr. Keys.
Oh,
Okay,
it says
nice
Jennifer,
to-
so I guess I made an assumption, so.
Sorry.
Jennifer Dan, yeah.
Okay.
Hey, so Minnesota has the 72 month or has that opportunity. Can Wisconsin, can that sunset clause be applied to a guardianship of that and then get reevaluated at that point?
No.
Because we do have, you can't put a
Nope.
sunset clause on guardianship. Okay,
Nope.
that was my
Yep.
question for that. Thank you.
Yep. And see, people will see temporary guardianship and think, well, I'll do that. And that temporary, that form is used for people who maybe have a psychotic break and the family member needs to intervene to help get them into mental health services and, help, for on a temporary basis while they get back to better mental health. It could be somebody has a traumatic brain injury and they need time to heal and they need somebody temporarily to help make decisions for them. So that's not what that temporary guardianship is for. And so we don't have that. If you're put under guardianship in Wisconsin, it's considered you're declared incompetent and there's no time limit on it. There are some of us that have talked about wanting to do that. But it's a challenge. So
we do have a brain injury child that's 17 that's going to need a few extra years to be able to make decisions on his own. And that's so we're at that point of where this is going to be a problem. It will be a problem if we don't continue to be a guardian of him and to make the right decisions because he's catching up. But that catching up will take another half a dozen years.
Yep. And I mean, it can be removed, terminated. I was in a court for a guardianship and there was one ahead of me and it was an individual who had been in a car accident. He was in his 30s. He had a traumatic brain injury. He needed guardianship. His mom had guardianship, but he had made strides. His brain had done some healing. And both his mom and the support workers had, said that the guardianship can be terminated. he still needed supports. They outlined the plan for how he would be supported going forward. And in fact, at the end of that hearing, his rights were restored. The guardianship was terminated. But the mom was supportive. The people who worked with him, so they had witnesses who were willing to testify. They had medical documentation. I mean, it's not just you go in and say, you've got to overcome that presumption of incompetency. When you go in the first time, you're presumed competent. Now you're incompetent. So now it's like, okay, this is what you said 8 years ago. What's changed? How has it changed that, it just can't be, oh, we think we should terminate it. So that's why I say they can be very challenging to undo. Another one, we use this as durable power of attorney, so that I can help with finances. People will probably be doing these with their elderly parents. You could do it with somebody who's going to be out of the country for a while. Say you have a loved one who's a service member and they're being posted overseas. They could sign a durable power of attorney, and you could take care of their affairs, pay their taxes on their home, pay their insurance premiums, that sort of thing. Thing about a durable power of attorney is it can be revoked by the person who signed it. So that's what some people, they say, yeah, we can have that, but they could terminate it. That's true. You can have a power of attorney for healthcare, which can be helpful. Custom releases. You can get releases from like the healthcare providers, or, depending on your circumstances, you can look. And for someone like me, it was, I could do custom releases. It may not be as easy for someone who isn't a lawyer, admittedly, but it's the whole idea. It's thinking about what are options, what other things can we do. I see Michelle has her hand raised. Go ahead, Michelle.
Yeah, I just had a quick question.
Sure.
So those power of attorney things, do they have to be notarized in order to be legal, or can we just like draft them up, sign them, and say, here you go?
No, they have to be notarized.
Okay.
Yep.
Okay. Thank you.
Yep. And then you can do limited guardianship. And I was, when we were going through the petition, that's why I was pointing out in that first section that maybe they lose their right to execute a will or serve on a jury, but they retain their right to vote. You've already created a limited guardianship almost by definition by just doing that. They can still have the right to vote. And then you can go down through those other rights that they have. And my example of the money, they can spend up to, they're limited to spending up to $500 because they have a job. And, if they want to spend money on a gaming system, then it's $450. They should be able to do that. They've earned it. That gives them a sense of decision making, a sense of rewarding themselves for efforts that they put in on the job. So then that's to me what there should be more of if you're going down the guardianship path is, and that's why this talk and you educating yourself as parents to say, don't just check all the boxes. Maybe we should be limiting it. Supported decision making is not just a form. There is a form. There's a lot of forms in the law, but it's more of a thought process. It's more of a value system where we're going to support our loved one making the decision. And this is what it is: a series of relationships, practices, arrangements, agreements. It can have more or less formality and intensity, but it's to help a person with a disability make a decision and then communicate that decision to others. I mean, I've run across people because I work with that agency I said earlier about I'm on the board and been for years. If somebody has a guardian, and I have when people come into my office, the person, who is it that you're addressing? And there's a tendency that if there's a guardian, you start looking at the guardian. It's the individual in their guardianship whose life we're talking about. It's, are you communicating with them? do they just go disappear in the background and you're just talking to the person who pushed in the wheelchair, if you will? It's identifying, and with supported decision making, you could find somebody. I always say, because I've gotten tired over the years, is I would love to have a peer of my son be supportive of his decision to buy a gaming system, so I don't have to learn about the new PS5. Okay. That would be great. And they could talk the same language, and they could go to a store, and they could be online, and I don't have to be involved in that. And maybe he's going to spend, $700. Well, he works. He should be able to spend $700 on as long as his other bills are paid. Yeah, great. He saved money for it. But as a way for him to get practice of helping, of having somebody else. And that's an example of a small decision, but trying that. It's limited, but you could have somebody, maybe family members is in the healthcare profession, healthcare field. Maybe they'd be a good one to do supported decision making when they're older, when they have to go to the doctor. So those are the ones. And I want to give credit, Kate Schilling. She's a friend of mine. She's a lawyer down south, Madison. And this was one of her slides, and I stole it. So I like to give proper attribution. It's still developing, the supported decision making. A lot of when Wisconsin did it, I think we were the 7th state to do it. A number of other states have followed. I haven't followed up that much about what those other, who those other states are, but Minnesota doesn't have it. I know advocates over there who would like to have it. I gave a presentation about our supported decision making law, oh gosh, a number of years ago, to a group of lawyers and judges to give them some exposure to what we did. And these are the values of supported decision-making: autonomy, self-direction, equality. It's the least restrictive. That's one of the concepts that the judges should be looking at. Is a guardianship the least restrictive? What have you tried before guardianship? Where, more judges are asking that question now, which we like, which we want to see. Developing trust, developing respect. And again, another slide I sold from Kate. So other lawyers are talking about this. Other people are, into this topic. Other concepts we've talked about: presumed competence. Dignity of risk is another big one. I mean, we made mistakes. I'm sure my parents shook their head on some of my decisions. I took a risk. It was a bad decision. We have varying levels of impact of some of our decisions, which, you don't want life-threatening ones, but take small steps. There have been a couple of purchases that have been made with, my son's made with his debit card that probably not the best decision, but we talk about it. He's learned that lesson. He doesn't buy as many power-ups in his in-game power-ups. They can be expensive, and you're not really keeping a tally of, the rewards or the things you use in an in-game process. So we talk about that. We talked already about the difference between a substitute decision maker, a guardian, and a supported decision maker. These were some of the states way back when I started doing these talks. Vermont, it surprised me that Texas had supported decision making before Wisconsin. That was a surprise to me. But go Texas. There's a number of groups that have been involved and been made aware of. Wings, that's a grouping of lawyers, judges, and professional guardians. I spoke at a conference down in Madison and a panel, and the person who sat next to me was a neuroscientist from UW-Madison, and that's where I got some of my information about brain development. They've actually done the MRIs and the fMRIs to see what lights up and the connections that are made. So those are the kinds of that's what's in Wisconsin. We do this training. There's self-determination training that people can get. The statute is Chapter 52. And so if you do Wisconsin statutes, Chapter 52, then the supported decision-making law will come up. I won't go into the case from Virginia, given our time. It's over 10 years old, but essentially it was a woman with Downs who fought her mom and her stepdad to get out of a guardianship, and she got support for it. And it turned out that after a year of guardianship with an effort towards enhancing her skills and giving her the right support, it was terminated. These are some of the resources. I'm assuming that either the presentation or this slide can be made available to people who are on this Zoom meeting.
You're absolutely correct, George.
okay.
We will send out a copy of the slides as well as the resource sheet. One of the questions we have is,
Sure.
are you willing to share your contact information if people have questions after the
I'm trying
thing?
to
Do you
think
have
if
like
I
an
have.
email or not? Or
Well,
or you
if
can
you
talk to
if you
me
search
afterward.
for George Zaske attorney, I'm going to come up, and
Yeah, you
I'm
will.
the only one.
Yeah, you are.
But I guess what I would say, and then it has my email contact information, and I do take calls and emails from people. The only thing the thing that I ask is put some reference in the email or in the voicemail or however you reach out to me that, I saw your presentation. So I have some sense of kind of where it's coming from. Because sometimes, doing a guardianship, I can't really do a guardianship for somebody in Racine County. I can do a guardianship for somebody in St. Croix and Polk and Dunn and Pierce and, in my area, Eau Claire. But, I'm willing to take questions from people. I mean, I do this for a reason, because I want to see the world change. And part of it is selfish, because if the world is more open to supported decision making, it's going to be more open to my son and others like him. And we continue to move and improve things. Surprisingly enough, Greater Wisconsin Agency on Aging Resources, buried in that website is the Guardianship Resource Center, which is a little bit for younger families and people in the 18 and 20-year-old range. You wouldn't expect it to be in that, under that agency, but that's where it is. There's a national resource center for supported decision making. There's information at the DHS. The supported decision making forms. There's a packet with BPDD, because we do actual trainings on just supported decision making. We go through the form. The thing about the form is it's not a silver bullet. Part of the rationale for having it is so that other bureaucracies and systems would have something else to put in their file, and gives them some liability protection under the law. Because otherwise it's like, you hear disability, then they now many of them just go to, okay, who's your guardian? And we're, part of this process is to in fact change that. And then Minnesota had a really good YouTube set of videos that were hosted by Jonathan Martinez, and he's probably considered the leading expert in the country on supported decision making. He was actually the lead attorney on that Virginia case. I've met him a couple of times. I've heard a number of his presentations, and he's the one that did those YouTube videos for the Minnesota Department of Health Services. So, questions? 1 minute before 7. And I'm willing to stay past 7 if other people are. So.
Yeah. Thank you so much. I am looking over the chat, so please feel free to put your questions in the chat. Also, feel free to raise your hand. We will be able to see that. I will remind you that we are being recorded, so no personal identifiable information we ask of you. So any questions? What age do you recommend people begin the process? And I'm not sure if they mean for guardianship or supported decision making.
Well, in supported decision making, I mean, we've tried to get to teachers, younger so that that concept becomes familiar. What we've seen in the past and what research and sort of anecdotal has shown for us is when a child gets 17 and a half, there's kind of this rush. The IEP team says, is your kid going to work? Have you gotten Social Security benefits? Have you signed up for long-term care? What about guardianship? Where are they going to live? And there's this huge push at that time. Legally, you can start the process of getting guardianship at 17 and a half. But if you don't get it at 18, again, weighing the risks. If your child lives with you, they listen to you, you don't have maybe a fighting family dynamic where they're really oppositional and they're saying, they slam the door and they say, when I turn 18, I'm moving out. And yeah, but if it's like, oh, we have another year, we're going to do another year of high school, they're going to live with you, you're the one that drives them places because they can't drive. I mean, okay, where are the vulnerabilities? Where are the opportunities for that kind of stuff to come in? And, I don't know your personal situations, but it might be that that's pretty remote. We can, we'll have them sign a power of attorney. I mean, when my son turned 18, we did a bunch of signings before we got birthday cake, essentially. So we could get that taken care of and be able to go from there. But if for whatever reason I have a much better sense of if I had to do guardianship or go that path, it would be limited and I would have a very narrow scope about what it ought to be, because there are some areas that we still need to work on. And he works with us, he trusts us, he knows he can make decisions, he knows if he makes a mistake, he's not going to be made to feel small because we point out, yeah, that wasn't a good purchase, but you earned it. You can't buy this thing now. So that he has the natural consequences. But if push came to shove and it's like, oh boy, complex medical procedures, maybe some other family member should really be involved with that. So, but so far I haven't foreseen a need. And as I said, he's 26 and we haven't come across a scenario where it's like, oh geez, if we only had guardianship. But again, our circumstances, our approach, our loved ones, skill set and developed skill set. But 17 and a half is when you can start that process.
I'm a little confused. Is limited guardianship the same as support decision making?
No. When I use the term limited guardianship, I'm in that guardianship petition, but I'm not checking every box to limit. I'm limiting the powers I'm giving to the guardian. That's what I mean by limited guardianship. I'm saying you can't make a financial, the person who's under guardianship can make financial decisions of spending up to $500. If it's over 500,000, 500 in my example, to buy 5,000 to buy a car, they don't have the authority they can't do that. I need to make that decision. If I have that. So it's limited within the petition.
Okay. And would a court recognize a limited guardianship within that petition? Would they recognize that as that these are the areas that have to be worked on?
Yeah, I mean, that's what you're in court to do. That's what the court order would say. You're going to get a court order, a guardianship order out of that says this person has their right to retains their right to vote. This person can make financial decisions up to $500. This person can decide where they want to live.
Okay.
You'd have to go through that, with an eye towards your loved one's skill sets, your loved one's, decision making, and where it would be, where it could be limited, or whether you want the full rights to be removed and given to the guardian.
And
Um,
George, have
so-
you ever had a case where someone went in and said limited guardianship and the judge said, oh no, it's full guardianship. We're not doing
No,
limited."
because you as the petitioner, I mean, your evidence is you're setting up, and it could be, okay, judge, he he works. He started working when he was 16. He has a bank account. I'm joint on the bank account. He's bought this, but he's bought some of his, his own clothes. He has a debit card, for the last 6 months. We haven't seen him, make any weird, outrageous, crazy purchases. The court defers a lot, and that's why a lot of guardianships were put on, full guardianships that maybe weren't appropriate, because the court's going to defer a lot to who knows best, mom and dad, right? They want the parents want to take care of their loved one. They want to keep them safe. So it's really, kind of weighted towards what comes into the court from the parents. Now, I would also point out a guardianship can be contested by the person who's being who could be a subject to a guardianship. They have a right under the law to get independent counsel and fight it. So that's something else that sometimes people go, really? My kid can, yeah, yep. Because the potential is they lose a lot of their rights. And sometimes even parents may not have the right perspective. And maybe the person needs to be under guardianship, but a person maybe that shouldn't be the parent. I had a friend of mine do a case where the dad wanted to move their loved one to a different group home to get away from her boyfriend, and they went on dates by sitting on the sofa watching Packer games. But he didn't like that, and he wanted to protect her, and he wanted her living closer by, and have a lot more. And she was not too happy about that prospect, and she was able to find resources through the disability rights to be able to get an attorney to fight dad from picking up and moving her for that reason.
So I'm going to do a couple things here.
Sure.
Number one, I'm going to thank everybody for being here. I'm going to allow people to go ahead and leave. George, if you could hang on, I'm going to stop the recording. There is a question chat that I think would probably be better answered, or at least your opinion on it, not being recorded.
Okay.
Okay. So thank you all for being here. George, do you have any final words before I cut off?
I just say to people who've taken the time, this is what we need to have more of, is people educating themselves, parents educating themselves. And I said, if guardianship's appropriate for your loved one, if it's a full guardianship, okay. But you know a little bit more about what it is that you're embarking on, and what you might be handing over, powers you might be handing over to a sibling or somebody else. And we can have discussions about what happens if a sibling gets appointed to be guardian. My sister, I run across young people, and they're not too happy about the prospect that their sister or brother at some point in time is going to be able to decide for them. There's lots of layers here. This could be the start of a journey, and get those resources, read them, sit on them, have family discussions about them, because these are some very closely, deeply held, values and belief systems that are going to be under some scrutiny, and where you're weighing the dignity of risk versus absolute safety.
Right. Thank you so much, George.
Yep.
I'm going to stop the recording, and then if do you have access to the chat, George? Can you see that question?
If I click on it, I suppose I do.
Okay.